Joanna and other people have dealt with the broader questions, and Professor Azalea mentioned the notion of the structure of EU law. I think that there's a case coming up that might be able to deal with more specific issues and tease out how Zambrano might impact on future cases before the Court of Justice. And I've chosen to discuss the case of McCarthy here because I think that it's sufficiently similar to Zambrano that it would be relevant as the next stage in the development, but it's also sufficiently different that it should be able to provide some clarifications and some distinguishing factors. So what I'll do is I'll just give a very brief overview of the facts and the opinion of Advocate General Coutts in McCarthy. The judgment has not yet come out, and contrast that opinion then with the opinion of Sharpstone, because they were quite distinct and quite different. And then finally, I'll assess ways in which McCarthy might clarify certain aspects of Zambrano. As has been mentioned, Zambrano is very ambiguous, very short, and is somewhat cryptic, so hopefully we might get some of the answers to the questions that are being posed here today in McCarthy. And that's the sort of theme of this presentation as well. It's more about seeing what questions will be asked rather than providing the specific answers. So just a few, as I said, unanswered questions that were raised in Zambrano. First of all, what is the actual substance of the rights that are mentioned, that are conferred on EU citizens? And secondly, and this is an element which might become apparent in McCarthy as I go into the facts, would this be subject to conditions and limitations, which is mentioned specifically in the treaty? And finally, the broader question, the elephant in the room, what role do fundamental rights play? Because the court didn't address this in Zambrano explicitly, but it might perhaps be forced to, or might arrive at the question of fundamental rights in McCarthy. So just a very brief overview of the facts for people who aren't familiar with McCarthy. Shirley McCarthy is a British national who has never lived abroad. She receives state benefits and there's no evidence of employment. This is relevant when assessing whether conditions and limitations can be applied to the residence of citizens. She has married Mr. McCarthy, a Jamaican national who has no right of residence in the United Kingdom. However, shortly after Mr. McCarthy's marriage, she applies for and receives Irish nationality, once again Ireland in the foreground. This is on the basis of her mother's birthplace, I believe. And she receives that Irish passport. And on the basis of that passport, she has applied for residence in the United Kingdom based on European Union law rather than her status as a British national under Directive 2004-38, relying on Chen. And then in a separate action, Mr. McCarthy has applied for residence based as a derivative right of residence. So another little attempt at clever lawyering for immigration lawyers in the United Kingdom. In the two questions that were posed by the tribunal, in contrast to Zambrano, focused specifically on the directive and are relatively narrow. And the first question is relatively simple: can Mr. McCarthy be considered a beneficiary within the meaning of the directive? And then the second question is, does her stay in the United Kingdom as a British national, can that be counted as residence for the purposes of the directive? I don't think the second question is as relevant to what we're discussing today, so I won't deal with that in depth. So in relation to the first question, whether Mr. McCarthy can be considered a beneficiary, Advocate General Coutts focuses very, very strongly on the notion of movement. So she says that the concept of beneficiary is restricted to those who have exercised a right or who have exercised their freedom of movement. So the movement rationale, rather than a separate residence rationale, appears to be the line that she takes. She makes very brief reference to the notion of primary law. She says that secondary legislation is to be interpreted in conformity with the Charter and with the treaty, but she is satisfied with very little development of reasoning that her interpretation that the directive is linked to movement is not affected by primary law, that it is in conformity with primary law. When dealing with the issue of the dual nationality, which is something which I'll come to a little bit later as well, she uses a discrimination framework, and she distinguishes it from other cases of dual national citizenship, such as Garcia Ovella and Grunk and Paul, the name cases, by the fact that the applicants, in those cases, the fact that the applicants were dual nationals made their situation different to, shall we say, single nationals. Whereas in this case, in respect to residents specifically, apparently, according to the Advocate General, dual nationals and single nationals are in the same situation, and therefore no relevant fact arises, or the fact of Mrs. McCarthy's dual nationality is not relevant. Now, she doesn't call into question, she doesn't believe that it should be called into question the grant of nationality by Ireland, and this is a relatively traditional approach and follows the court's case law on this issue. And then finally, in discussing reverse discrimination, for the moment, the Advocate General believes that it is a matter for national law. Perhaps in the future this will change, but this in particular is not a good case for that change to occur for want of sufficient resources. And the implication of this is that even as a mobile citizen, Ms. McCarthy would not have a right of residence, so therefore this wouldn't actually fall into a case of reverse discrimination. So, just a very brief overview of the divergence, the differences between the Advocates General, Sharpston and Coutts between these two cases. Firstly, Sharpston concentrates very much on primary law and discusses fundamental rights and takes a far broader picture. Advocate General Coutts focuses on secondary law and the directive. This could be a function of the questions that are posed by the tribunal that reflects the two sets of questions that are posed, but it's just something interesting to note. Secondly, Sharpston believes that the right to move and reside are in fact two separate rights. There's a right to move, and then secondly there is a right to reside. Coutts focuses very much on the combined reading of the rights, therefore there is a right to move and reside, a single right. In relation to reverse discrimination, once again they take opposite opinions. Sharpston believes that reverse discrimination in specific circumstances should be prohibited by Article 18. Coutts does not believe that the time is right for this development in European law. And then finally, the role of fundamental rights. It's not really dealt with in McCarthy opinion, whereas in the Zambrano opinion, Sharpston calls it the leitmotif of the entire case. So the possible clarifications that we might see in McCarthy are at least the four main ones. Firstly, the scope of secondary law, and this is presumably just a confirmation of what we see in Zambrano. Secondly, what exactly the substance of these rights, this cryptic substance that we hear in Zambrano might be. Thirdly, the question as to whether conditions and limitations might be applied to those rights. And fourthly, the role of fundamental rights. So firstly, the question of secondary law. I've just taken the quote there from Zambrano, and it would appear that the directive and that the court's reading of the directive would require movement, or at least that one wouldn't be a national of the host state. So, as I said, there's no further reasoning other than this in the case. So, I just put in italics: to move or reside in a member state. They or might imply that it's disjunctive, but other than that, which they're a national. Now, in any case, Ms. McCarthy, as a dual national, is also a national of the United Kingdom, which is, in fact, a contrast to Chen, where baby Chen was only a national of Ireland, rather than she was not entitled to British nationality. So this might indirectly also lead the court to deal with the issue of dual nationality, and as to whether the dual nationality or nationality in another state might indeed be a connecting factor which might bring them into European law, or whether it's relevant at all. So this might lead the court to discuss the issue of dual nationality and also the scope of the directive. So then the scope of the rights under Article 20. So it's what actually are the substance of the rights conferred by the status of citizens of the Union. In Zambrano certainly seems to imply a right of residence, and this is the reference to that the children will be forced to leave the territory of the Union, and would appear to imply a right of residence. So then the question arises, and I think Kiva already flagged it, is how far does this right of residence extend, and in particular does it contain derivative rights for other family members? And in this case, it is third country national spouses. Now, Kiva concentrated, and I think this is important, on the parental, the care element of the case, which perhaps doesn't exist in McCarthy because it's two spouses rather than a child and parent. So it is less clear in the case of parents that denying a spouse a right of residence would necessarily affect the very substance or deprive the Union citizen of the genuine enjoyment of the substance of the rights. So we might get some clarification as to, as I said, the scope of what sort of derivative rights are protected under Zambrano. Then this is just an issue which was raised in the opinion because, as I mentioned, Mrs. McCarthy, this is the conditions and limitations. Mrs. McCarthy doesn't appear to have independent resources. She's reliant on state benefits, which would normally preclude somebody from enjoying rights under the Citizenship Directive, or within certain limits. So then the question arises that if Mrs. McCarthy does in fact enjoy a right of residence under Article 20, can conditions and limitations be imposed on that right, and what the implications of that might be? But this is I'm slightly confusing because the wording in Zambrano saying that the very substance of the rights would have to be affected might already incorporate a limitation of those rights, or a consideration of the limitation of those rights. So it will be interesting to see if, as I said, the member states, if a right under Article 20 is recognised for Mrs. McCarthy, whether that right can be subject to limitations and conditions such as sufficient resources. And then finally, the issue of fundamental rights. As I said, so if the right does exist, and if there is interference, and if that interference might be considered legitimate under the limitations and conditions aspect, can Mrs. McCarthy then rely on rights of fundamental rights? Because the right of residence of a spouse has been recognised as an aspect of the right to family life by the Court of Justice in previous case law. We've mentioned Carpenter before. So this might, if it does lead to the situation where a right is recognised for Mr. McCarthy, where conditions might be placed on that right, and it might lead the court to address the issue of fundamental rights in such a situation. I said there's no mention of fundamental rights in Zambrano. On the opinion in McCarthy doesn't mention it at all, but as has been mentioned, Sharpston's opinion goes into quite in-depth analysis of the question of fundamental rights. And I just quoted here the passages from Sharpston. I think it might be a fitting part to conclude, because she believes that perhaps that the fundamental right cannot currently be invoked as a freestanding right, independently of any other link with EU law, but that the Union might now be on the cusp of constitutional change. Answering that question cannot be put off for the moment, or probably can be put off for the moment, but probably not for all that much longer. So we might see that issue, that moment arise in the case of McCarthy. So, as I said at the beginning, I think McCarthy is an interesting case, and it's good to be aware of it. It's sufficiently similar and sufficiently different for it to be relevant and to be useful. And there are particular issues involved, which I've mentioned, such as the substance of the rights, the notions of limitations and conditions, the role of fundamental rights. But I think perhaps generally as well, we might see in McCarthy as to whether the court is willing to push Zambrano a little bit further beyond the quite exceptional cases that we've seen in Zambrano and perhaps Rotman, where the very status or the enjoyment of the rights was threatened. As has been mentioned, Zambrano is quite a sympathetic case. McCarthy is perhaps less so because of the various different facts. And therefore, I think that we might see, as I said here, an indication as to whether the court is willing to apply, as we say, Zambrano doctrine to beyond the sort of rare and exceptional cases, and if it will be applied more generally. And yeah, I think